Hello, welcome to the 190 literary and jury charge portion of the class. I'm going to start out with a small article called Don't Sweat the Small Stuff. Ready? Often we allow ourselves to get all worked up about things that, upon closer examination, aren't really that big a deal. We focus on little problems and concerns and blow them way out of proportion. A stranger, for example, might cut in front of us in traffic. Rather than let it go and go on with our day, we convince ourselves that we are justified in our anger. We play out an imaginary confrontation in our mind. Many of us might even tell someone else about the incident later on, rather than let it go. Why not instead simply allow the driver to have his accident somewhere else? Try to have compassion for the person and remember how painful it is to be in such an enormous hurry. This way we can maintain our own sense of well-being and avoid taking other people's problems personally. There are many similar small stuff examples that occur every day in our lives. Whether we had to wait in line, listen to unfair criticism, or do the lion's share of the work, it pays enormous dividends if we learn not to worry about little things. So many people spend so much of their life energy sweating the small stuff that they completely lose touch with the magic and beauty of life. When you commit to working toward this goal, you will find that you will have far more energy to be kinder and gentler. Okay, I have some jury charge for you. This is on negligence, and you can use the brief NEJS for negligence. Negligently, just come back for the L long E. And negligent, I just use NEJ. Ready? Members of the jury, the defendant at the time of the installation knew of the explosive character of the gas to be used in the operation of this gas stove. So the question here presented is whether or not he exercised ordinary care and prudence in making the installation, which he did not or he did make. The test of negligence in this case is the same as in other negligence cases, that is, the probability or foreseeability of injury to someone. If the defendant might have foreseen that, under the circumstances, some injury to someone was likely to result from his act or omission, he is liable for any injury proximately resulting. The gas to be used in this stove was a dangerous agency of which the defendant had knowledge, and a higher degree of care is required in dealing with a dangerous agency than in the ordinary affairs of life or business which involve little or no risk. Such higher degree of care in such case is ordinary care under the circumstances. If a person fails to exercise the degree of care required of him in dealing with dangerous instrumentalities or agencies and negligently permits a danger to exist which results in injury to another, without negligence on the part of the person so injured, he is answerable for the injury so sustained. The degree of care varies with the danger involved, and where the danger is great, a higher degree of care must be exercised. From anything the court has said or done in this case, you are not to understand that he has any opinion as to the facts appearing in evidence. It is the duty and province of the jury to weigh the evidence which has been introduced in the case and to determine what fact or facts evidence establishes, and having done so, to apply to such facts the law as stated in these instructions. Okay, I have a fun fact to read to you. Why is the word seed used when ranking sports teams in tournaments? In 1898, the American Lawn Tennis Association, the major governing board of the sport then called lawn tennis, was holding a major national tournament. Officials figured that the best way to disperse the top players and make things fair would be to scatter them like seeds so that they'd be separate and not play each other in early rounds. And then at the bottom here it says, rest in peace. Lincoln's body has been buried, disturbed, and reburied 17 times. Interesting, huh? All right, I have an article for you called No Hair Day. Ready? If you are turning 16, you stand in front of the mirror scrutinizing every inch of your face. You agonize that your nose is too big and you're getting another pimple, on top of which you are feeling dumb, your hair isn't blonde, and that boy in your English class has not noticed you yet. Allie never had those problems. 2 years ago, she was a beautiful, popular, and smart 11th grader, not to mention a varsity lacrosse goalie and an ocean lifeguard. With her tall, slender body, pool blue eyes, and thick blonde hair, she looked more like a swimsuit model than a high school student. But during that summer, something changed. After a day of lifeguarding, Allie couldn't wait to get home, rinse the salt water out of her hair, and comb through the tangles. She flipped her sun-bleached mane forward. "Allie," her mother cried, "what did you do?" She had discovered a bare patch of skin on the top of her daughter's scalp. "Did you shave it? Could someone else have done it when you were sleeping?" Quickly they solved the mystery. Allie must have wrapped the elastic band too tightly around her ponytail. The incident was soon forgotten. 3 months later, another bald spot was found, then another. Soon Allie's scalp was dotted with peculiar quarter-sized bare patches. After diagnosis of "it's just stress" to remedies of topical ointments, a specialist began to administer injections of cortisone, 50 in each spot to be exact, every 2 weeks. To mask her scalp, bloody from the shots, Allie was granted permission to wear a baseball hat to school, normally a violation of the strict uniform code. Little strands of hair would push through these scabs, only to fall out 2 weeks later. She was suffering from a condition of hair loss known as alopecia, and nothing would stop it. Allie's sunny spirit and supportive friends kept her going, and there was some low points though, like the time when her little sister came into her bedroom with a towel wrapped around her head to have her hair combed. When her mother untwisted the towel, Allie watched the tousled, thick hair bounce around her sister's shoulders. Gripping all of her limp hair between 2 fingers, she burst into tears. It was the first time she had cried since the whole experience began. As time went on, a bandana replaced the hat, which could no longer conceal her balding scalp. With only a handful of wispy strands left, the time had come to buy a wig. Instead of trying to resurrect her once long blonde hair, pretending like nothing ever was lost, she opted out for an auburn shoulder-length one. Why not? People cut and dye their hair all the time. With her new look, Allie's confidence strengthened. Even when the wig blew off from an open window of her friend's car, they could all share in the humor. As summer approached, Allie began to worry. If she couldn't wear a wig in the water, how could she lifeguard again? "Why did you forget how to swim?" her father asked. She got the message, and after wearing an uncomfortable bathing cap for only 1 day, she mustered up the courage to go completely bald. Despite the stares and occasional comments from less than polite beachcombers, "Why do you crazy punk kids shave your heads?" Allison adjusted to her new look. She arrived back at school that fall with no hair, no eyebrows, no eyelashes, with her wig tucked away somewhere at the back of her closet. As she had always planned, she would run for school president, changing her campaign speech only slightly, presenting a slideshow on famous bald leaders from Gandhi to Mr. Clean. Allie had the students and faculty rolling in the aisles. In her first speech as the elected president, Allie addressed her condition, quite comfortable answering the questions. Dressed in a t-shirt with these words, "Bad Hair Day," printed across the front, she pointed to her shirt and said, "When most of you wake up in the morning and don't know how you look or don't like how you look, you may want to put on this t-shirt." Putting on another t-shirt over the other, she continued, When I wake up in the morning, I put on this one. It read, "No Hair Day." Everybody cheered and applauded. And Allie, beautiful, popular, and smart, not to mention varsity goalie, ocean lifeguard, and now school president with the pool blue eyes, smiled back from the podium. Okay. Got some testimony from the court. Okay. Here we go. This has been omitted from discovery. I think it becomes quite suspect. And we're talking about a man here of more than just average intellect. This is a man who deals with the law day in and day out. Certainly he knows what constitutes a legitimate agreement for entering into some kind of loan. He knows that if he died, for example, that may not be sufficient to cause his estate to obtain, upon a divorce, any kind of compensation for that kind of loan, or for his parents to collect upon the sale of any piece of property. I think the fact that he failed to get this document in writing, this alleged agreement of his failure to come up with any kind of a second trust deed, or make any kind of written record at all regarding this transaction, requires that the court see it for what it is, and that is a gift, pure and simple. And we would request that I think that the jury needs to see that this is a finding. These are issues that routinely come before this court in dissolution matters, and I take it fairly hard. It is a hard line when it comes to people alleging that these past transactions were loans versus gifts, because it's an easy allegation to make that a transaction prior was a loan versus a gift. Because in reality, what happens generally is one party is going to be paying half the debt, and the other party is going to be relieved of the debt from his or her relatives from whom the money was originally received. So consequently, I take a fairly conservative approach because it's an easy allegation to make. The court likes to see corroborating circumstantial evidence indicating to the court that in fact we do have an obligation rather than a gift. I don't require a promissory note, and I don't require a second trust deed. If that was the case, then the issue would easily resolve itself, and we wouldn't be here at trial. The court recognizes that oftentimes with family business transactions, oftentimes they're not reduced to promissory notes and deeds of trust simply because we are dealing with family members. That's probably not the best business practice, but it does happen with frequency. In this particular case, the court has a check dated January 21st, 2006, made out to both of the parties in this case in the amount of $20,000, signed by Mr. Netter Sr. with the designation loan. It appears to the court that the designation on the check was executed or signed by the same person under the evidence code. Obviously, I have the right to review signatures and handwriting for my own individual comparison. It does appear to be the same, and it does appear to be the same color of ink. It appears to be the same pen that was used to denote loan, or similar pen to denote loan, versus the signature. Also, I have the letter written, allegedly written on June 1st, 2008. That does carry less evidentiary weight because we don't have an envelope with a postage mark on it. This kind of evidence can be fabricated fairly easily. I'm not saying it is, and I'm not saying it isn't, but it is subject to fabrication. However, I have a second check dated May 30th, 2008 in the amount of $11,000, and that's been explained by Mr. Netter. The burden of proof here is by preponderance of the evidence. This allegation concerning the loan is attempted to be rebutted by the FHA transaction and the gift letter. I'm assuming that there was a gift letter that was submitted, and I accept the testimony of the witness, Mrs. Robertson. But again, relying on common sense, that doesn't necessarily characterize in reality the transaction that occurred between the Netters. It may well be a case of fraud against the government, but it doesn't necessarily refute the allegation made by Mr. Netter that the transaction was a loan. The court finds by the preponderance of the evidence that this obligation of $20,000 is in fact a loan to the community. The court so finds. The second issue regarding the ownership of this case is going to be reliant upon the next witness that will be coming on the stand. All right. I have an article here. This is called Court Reporters in Demand in Courthouses. Here we go. Ready? Jotting down someone's every word isn't easy. It's even harder when two people join in the conversation, or three, and they start arguing. That's life for Sonoma County's unsung legal heroes, court reporters, a tight-knit group of professionals responsible for typing up everything that is said in trials and other proceedings to create the official record. The 10 full-time and 4 part-time county court reporters are silent witnesses to both criminal and civil matters, providing real-time transcription to judges following on laptop computers. When they're not taking verbatim notes, more than 200 words a minute, they are preparing thousands of pages of transcripts a year for private attorneys or use their unique skills to provide TV captioning. You can't miss anything, says Barry Hart, a court reporter of 29 years. It's intimidating. The first couple of months I worked, I was scared to death. I thought I was going to throw up every day. A new study suggests reporters like Hart will be in high demand in the next 3 years, leading to a nationwide shortage. Market analysis Ducker Worldwide said 5,500 new court reporter jobs will be available by 2018 as older workers retire and leave the field. 70% of the nation's 32,000 court reporters are older than 45 years old, the report said. Demand is expected to be greatest in California and 3 other states. That presents a kind of golden opportunity for people who might otherwise be considering a traditional 4-year college education, said the National Court Reporters Association. Court reporting students spend less than half the time in school and emerge with about a quarter of the student debt, according to another study. With starting salaries in the mid $800,000 range nationwide, $80,000 range nationwide, and considerably higher in parts of the Bay Area, it's a viable alternative, said Sarah E. Nagate, the association's president. Students who graduate will hold more than a piece of paper, she said. They will hold a job. Those lucky enough to get hired in Sonoma County will be among the highest paid anywhere. The base salary is $98,000 a year, plus thousands of dollars more for private transcription work, said Carlos Martinez, a longtime Sonoma County court reporter and president of the California Court Reporters Association. Unlike other fields, court reporters own their work product and are free to sell it, he said. You can make up to half your salary or more, Martinez said. Sonoma County Superior Court is not currently hiring full-timers, but is always recruiting for part-time help. In the future, legislation requiring court reporters in certain specialties like family law will increase the demand, he said. They are very well compensated, but it is truly challenging, Golan said. They earn every penny of it. For reporters in the criminal courts, the day starts about 8:30 a.m., often at a frenzied pace, as defendants and their lawyers appear before the judges. They take their places beside the bench, tapping out proceedings on special shorthand machines and disappearing in chambers to record private talks involving the judges and the attorneys. They have a front row seat to murder trials and dramatic testimony. Some have strategies to keep up with the court proceedings. Hart channels and uses her musical talents. She's a blues singer and guitarist to take it all down. There's a rhythm to writing in shorthand, she said. It's like playing an instrument. Martinez, an ex-construction worker whose life is also a court reporter, said difficult times and technical terms can stump you. You ask for spelling and Google is your best friend, he said. And when two attorneys start talking over each other, he doesn't hesitate to put the brakes on. It's your absolute duty to tell them to stop or to slow down. The courts have experimented over the years with electronic recording machines. They are used in misdemeanor and civil courts, but many agree they can't replace the human counterparts. Martinez said there are thousands of examples across the country where machines have failed, sometimes resulting in cases having to be retried. They've been talking about it for years, Martinez said. Technology is getting better and at some point may be a challenge to certain facets of the profession, but there will always be a need for court reporters just because of the human element. Okay, that concludes our literary and jury charge for the 190 class. Have a great day.